Well, good evening, ladies and gentlemen. This is the April 5, 2022 meeting of the Board of Appeals regarding the application dealing with the residences at East Milton, Massachusetts. My name is John Leonard, and with me this evening are board members Jeffrey Mullen and Nick Gray. The purpose of this particular meeting is to continue the deliberations of the Board of Appeals. I believe this is our second deliberative meeting in order to reach a final decision on the draft decision and some supplemental comments that were made. So that's the purpose of the meeting tonight. A couple of things, I guess, to add to our record here. I did receive from Mr. Zawinski this afternoon at about 2:22 in the afternoon a series of comments on the East Milton decision from Joseph Prondak, our building commissioner. So I want to, thank Mr. Prondak and Tim Zawinski for sending these along. Without speaking out of turn, I think that the minor problem is that these comments are based upon the first draft decision that the board had before it, which I think has been substantially modified since that time. So I'm not sure there's a consistency between the comments of Mr. Prondak and the citations with the actual decision, but we can go into that. The other item of note is that we still haven't received back from Judy Barrett. I know she's preparing the revised draft decision, but we don't have that back at the present time to read and to reference. And I think the third item, perhaps worthy of discussion, is that Judy is not able to join us this evening until 7:30 in the evening. I think she's involved in another meeting at that time. So somewhat, she referenced in her email to me, which is about to 5 o'clock, 5:20 or something like that in the afternoon, that Mr. Zawinski is going to be present, and we thanked him for being present. But I'm not sure very technically, and I don't want to be hyper technical as to Tim's role in the deliberative process at this particular stage of the proceedings. So, Mr. Mullen, do you want to begin the session? Do you have any comments here as to what, if anything, we can accomplish this evening with the circumstances that I just referenced?
We should continue the hearing, John. I'm reluctant to have any comments until we have something in writing, I think, because each of the members have commented on the draft, and I know the building inspector has now got comments. So it'd be helpful to see the product of that, and then I think we can get on a call and deliberate. I'm mindful of the time, so I know there's hearings for Wednesday and Thursday, but I mean I could make myself available Friday or over the weekend or Monday at your pleasure.
Okay.
We actually Thursday is actually open, if that's helpful. It is. Yeah. One of the other cases just had to cancel. They're not prepared for Thursday, so that is open.
Who was that?
Do you know which hearing that was that got canceled?
Can't have.
Okay, what is that?
Oh, Crystal, can I just make, I'm sorry, John, can I just make a note? One of the things about these invites, Crystal, is many of the invites don't have the date, which hearing they are. So I'm not 100% sure which hearing is which night. So
okay.
So I've got all these blocked out on my night, but I don't know which one unless I'm, paying closer attention. So I had Wednesday and Thursday on my calendar blocked out, but I think Wednesday is Amor Road, right?
Tomorrow night is Amar Road. Yes.
Yeah, okay.
Thursday, I just had to cancel today.
Okay.
Canton Ave, we met last night. They're just not, there was a situation with one of the board members and they had to cancel for tomorrow night. So it was a last minute.
For Thursday.
Yes, it was a last minute cancellation.
Okay.
Amar is still on tomorrow night though.
Okay.
Mr. Nick, do you have any comments as to what can be accomplished this evening, if anything?
No, I'm just curious as to when, nothing beyond what Mr. Mullins already said, just curious when our 40-day period is up.
Well, that's what I was going to reference. I did recalculate that this morning, and I checked it actually with a brief conversation with Mr. Mullen, and we're both in agreement that the hearing process closed on this application on March 3rd, and that the decision would be due on or about Tuesday, April 12. Now, I did speak with Judy Barrett, and Judy indicated that she's had a confluence of 40B events. Oh, Judy's here. Hey, Judy, how are you?
I'm okay. And the board, how are you guys doing?
But I was just going to recite the misery that you're going through at the present time.
You don't need to do that.
I won't. Let me just ask you. Let me preface it and then ask you a question. When I spoke with Judy, we discussed the preparation of the revised draft decision, and we also discussed Judy's impossible position here. She's got the same thing they could do approximately at the same time, and both of significant length and complexity. So I suggested to Judy that I thought that the board here would not have any difficulty whatsoever, perhaps trying to extend the April 12th deadline by a couple of weeks if the applicant would so assent. And that would take the pressure off of Judy and the board and would produce a more deliberative and precise decision. So Judy, are you able to advise us whether you've had an opportunity to talk with Attorney Freeman, or where did that stand?
I did call Attorney Freeman this afternoon. I have not heard back from him. So I don't want to, say one way or the other where that's going to be acceptable. I think it would be probably not a good idea to assume that it is, if in fact they don't want to grant an extension. It's not like Peter to not get back to me, so he must be very busy too, like so many other people who are involved in the 40B world right now. I just don't know if it's acceptable, but I think, part of the difficulty I have is you've all kind of made comments here, and some of them really need to be discussed. It's not just stuff that I can just add it into the decision. Things that raise jurisdictional questions for me, things that, some of this is just, language that I think implies a condition, but isn't stated as a condition. So if you sort of think about the conditions section of one of these decisions, you almost want to be able to turn it into a gigantic checklist for the building inspector. And so every condition that involves something the applicant has to do needs to be stated with the verb. The applicant shall, whatever. So a lot of them are written that way, but then it falls apart and goes sort of into this other language that is not condition language. And I don't quite know what to do with it. So in some ways, it's just, I feel stuck beyond just timeline and competing 40B commitments. It's some of this content I'm just not sure what to do with. Well, so I think that you all may need to look at each other's comments here and wrestle with this. I mean, and John, I'll pick on you for an example, because I know you have such thick skin. You included in your suggested conditions, some additional language around landscaping and so forth from the planning board's comments. And some of that stuff is fine, but the whole preamble about why trees are important and all that doesn't go in conditions. It doesn't belong there. So the only thing that comes out of all that text is that the planning board, that the applicant shall, shall plant trees and other plantings consistent with the landscaping plan. That's really all we can say. And the rest
Why
of
don't-
it,
Then why don't we say it? In other words,
kind of already do.
what I think you're doing here, and I don't pretend to have expertise in this matter. I leave it to you. I thought what you were going to do is to take the three suggestions of the board members, which I think are somewhat discreet, incorporate them into one decision, and then we would go through that decision to see if verbiage needed to be tweaked, or if other comments were necessary, whether revisions or clarifications of the languages was to be done, but would be doing that off of a common document. And what concerns me here is that we have this draft decision, we'll call it the first draft, and then we've got these suggested modifications, and unless they're incorporated into the draft, even as suggestions, so that they show that these are my suggestions and Jeff's, and we tried not to overlap in our suggested modifications. We're dealing with pieces of the document rather than the entire document.
But I feel like I'm being asked to put a lot of content in this in a so-called consolidated draft that doesn't
Why
belong.
are you doing that? Because all we're asking you to do, respectfully, is to take our comments, give them to your typist, and I'm going to say this very carefully. I hope you're not the typist, because
I don't have a typist, John.
that's a
I don't
terrible.
have-
You should. That's a terrible waste of your time and your talent. So my thought, what you would do is you would give my section, and you would have that incorporated into the decision. You take Jeffrey's section, have that incorporated. You could reference this is JSL or this is Jeffrey, and then we'd have a unified document, which we could then go through and modify the language, listen to your expertise, commenting on the suggestion, and deal with it that way. Because if we deal with it in piecemeal, you deal with my suggestions, Jeffrey's suggestions, it's still going to have to be incorporated, and we're not going to know what it looks like until it's incorporated.
You're asking me to put content in here, even if it's only for discussion, that doesn't belong in the decision in the first place.
It's a draft, Judith. It's a
But
draft. You can reference that it is a draft. And by the way, this is the board's decision, and most respectfully, if you want to comment on our decision, feel free to do it. I don't care what you say about our decision, but I don't think it's your position to take what we're giving you and saying, well, that doesn't go and this doesn't go, and for these reasons. I think we want you to present us with a draft decision.
With non-jurisdictional content in it?
Well, you make the decision as if you're a judge as to what's jurisdictional and what isn't. We're delighted to hear from you. I thought we were going to appear tonight and I did check. My edition here was sent in on the 26th of March, I think it is. And Jeffrey's was immediately after mine. And I thought we were going to have a draft decision this evening to discuss. And I learned that at the 11th hour that we don't have anything to discuss. I don't know what progress we can make if we don't have a decision to discuss.
Okay, so my assumption is that you all have each other's comments. And
we do, but they're not in a draft that we can use as a base to comment on.
I'm not going to argue about this. I'm going to ask the following. Why don't you ask Crystal? Crystal's probably going to kill me for saying this. Ask Crystal to get all these comments into the draft.
Well, wait a second here, because it's not Crystal's job to do
Well,
that.
it's not, Mr. Chair,
Look at it. You're the consulting company. If you can't type it, and I understand, I don't think you should be typing anything.
it's
You should have
beyond, it's
some
not
to it.
normally what we do anyway, John. I mean, MHP sends me out to work with boards to do specific things. And there's just a point beyond which I have to say, I can't do this. So the
What do you
best I
mean?
can come up with is,
If you're saying you're too busy, then I say, let's continue this decision for another couple of weeks, and we'll get it together in workable form, and we'll discuss it. I'm not trying to jam you into doing a decision that you don't have time to do.
I don't know that you're going to get that concurrence from the applicant because I was not able to reach Attorney Freeman.
Well, that's
So
all right. Let him deny our request for a continuance. And I assure you that we'll have something to file on April 12th. And whether Mr. Freeman likes it or not, it'll get filed and it'll get appealed to the HAC or it'll get appealed to the Superior Court, and everyone can go their merry way and spend tens of thousands of dollars wasting everyone's time. If they want that type of a jam decision, they'll get it. Our decision's not going to be final in any sense. We all acknowledge that. Our decision, good, bad, or indifferent, has absolutely no probative weight before HAC. And I thought we were going to make a lot of progress tonight. I don't see how we can make any progress tonight the way on the basis that we're proceeding. Now, I'm not going to make decisions for the board. I've got two board members. I'd love to hear what they have to say as to where we go from here. Mr. Mullen, what do you have to say?
I'm thinking that one thing I could do is I could have your comments, John, typed into the draft that I wrote, I edited, and accommodate Nick's comments, and I could produce to the board probably tomorrow afternoon one consolidated draft that I'll give some thought to. That will at least give you something to work with. So I'll make that offer. I think I can comply with that. In the meantime, I think I'm interested in whether the applicant is willing to grant an extension. But I think we should postpone the deliberative discussion of this hearing until a later date. Crystal indicated Thursday was available. Maybe we should jump on that if we can.
Are you available, Judy, on Thursday evening?
I'm checking my calendar now. Oh, it's difficult for me to say. I'm scheduled to run a remote session for a community meeting, but it's not clear that that's going forward. Why don't you assume that I'm available for now? And let me see.
I think we have to, Judy, because if we don't, I don't want to reschedule it to Thursday, because I think without your presence, your review of the decision that Jeffrey at Foley Hoag's expense is going to prepare, it'll be a waste of everyone's time. Nick, do you want to be heard on where we are here, please?
Yeah, I am grateful to Mr. Mullins' offer of his firm's resources to put together a unified decision. I would be happy to meet on Thursday to discuss that and try to make as much progress to getting to a final decision so that we don't need to extend the hearing. I don't know if that's possible, but I'm willing to work on it.
Well, I'm not sure it is possible because we haven't heard Judy and her comments, which we welcome. It's not that we don't welcome your comments, jurisdictional or otherwise, but I think the board thinks that if we're working off of a common decision, we can eliminate things, we can add things, and we can incorporate. One of the difficulties that may be, I don't know if we produce a new draft, call it the second draft on Thursday, whether we're able to incorporate Mr. Prondak's suggestions or decision comments, so-called, because this is as to the first decision, and it may be difficult to find these spots in a revised decision, but maybe we can try to do that and do our best, but it may be difficult and time consuming.
I'll do that.
Chair, I think under the circumstances, you should probably send an email to Attorney Freeman and formalize the request for an extension. I think it should come from the chair.
Well, I have no difficulty doing that. I don't know that that's, it may very well be. I don't know. I have no problem asking Mr. Freeman for an extension. I don't think it's the way it's done in the real world, but that's what you want me to do, if that's your suggestion.
Yeah, actually, it usually is that the board communicates with the applicant. I'm happy to do it, but I haven't heard back from him, and I am concerned about the communication being clear to him.
Yeah, I don't really think, I'd be shocked if that's an issue, Judy. I think the circumstance is such that regretfully, Attorney Freeman is probably busy as you are, and everyone who practices in this discipline seems to be, including our peer reviewers, is put under intense pressure with the press of current business, and I think that's what it probably is. But I certainly will send an email to Attorney Freeman first thing in the morning and see what his response is. Let me do this. We're talking about going over to Thursday, which is the 7th, I believe. Mr. Zawinski, Tim, are you by any chance available on the 7th?
I am not available on the 7th, Mr. Chair. I have 2 different conflicts that evening, so I won't be able to make it. I do have to, given the uncertainty of this extension from the applicant, I really do think the board would be not doing itself a favor by at least starting to go through some of the comments that you all have access to. I've read through everyone's comments. I think there are some big ones that, one way or the other, whatever format these comments come in, whether they're, handwritten or in the margins of a Word document or in a consolidated decision, you're going to be talking about them. So I think, John, for instance, you had a rather, you had a lot to say about the financial feasibility kind of issue that came up during the hearing. There's a lot of content there. There's a lot of context there. I think, even if you've spent a few minutes tonight talking about that and sorting through the issues around that and kind of what that language is going to look like, I think you'd be well served to do that, to say nothing of some of the additional comments, because, again, I don't want to see you guys caught flat-footed if the applicant doesn't accede to an extension. So again, that's just my opinion. John, you're right to wonder what exactly my role is here. I think it is just to provide advice. So that's my 2 cents there.
Jeffrey, what do you have to say?
I don't know what to say, to be honest. I'm happy to, I'll do whatever the pleasure of the board is.
Nick, do you have any comments?
I don't think so. Are we able to do any of what Tim is suggesting?
Well, I guess we are, if you're prepared to, I guess if you have each of the 3 submittals available, and sure, we can do it. It may take a couple of hours, but maybe it won't. I don't. All I can tell you is, as a layman who knows does not have expertise in this area, And I want to rely on the advice of skilled and experienced consultants. I didn't perceive when the three separate commentaries were rendered that there were any substantial or more difficulties with the suggestions or the language. But if there is, let's, since we don't know what the language should be, I guess it's up to Judy to tell us what she thinks the language should be or the recommendations should be or whatever. We've submitted them for comment, and so why don't we go through them, Judy, if you like, and pick which one you want to go through first, and we'll go through what should be included and what shouldn't be included, and we can discuss why or why not. Are you prepared to do that tonight, Judy?
I can certainly screen share the document. It does not have all of the additional text in it that you had suggested, John, because I just don't have time to type all that in. But I can certainly go through up to that point. So if I have screen share permission, I'll be happy to do it.
Well, you have permission to do anything you want. You're our consultant here, and we're relying on you for these things. It's just.
So
is this Crystal? You put that up, Crystal?
no, I did.
Oh, you did. Well, thank you very much. Okay, so let's go to it to the extent that we can.
So, as you know, I'm not an attorney.
We know that. We don't expect you to be an attorney.
Good, thank you. The term nominal applicant, I have never seen in any comprehensive permit decision.
Yeah, that's right. And let me tell you why I use that word. I think the evidence is unmistakable that this applicant, Adams Court Property Owner LLC, does not exist. It is not a corporation under Massachusetts law. Therefore, it is nothing. It has no legal existence whatsoever. And to be frank about it, I am shocked and I guess dismayed that this whole process can be filed with the various state agencies, the various state departments, the Massachusetts Housing Board, or whatever it may technically be called, getting a response to what they think about as questions about the application. And nobody, not one official, has questioned whether this applicant is in existence, and it's not.
This is pretty standard. It's just that it's pretty standard.
I don't know how they can maintain an action if they don't exist. I mean,
How can that be
it's
standard?
but it makes no sense whatsoever.
Judy, tell me, in the last 10 applications you've processed, how many applicants didn't legally exist?
I don't believe that Charlie's did when he applied for
Well,
the.
and if you knew that, you told us that.
I didn't know that. It's just so standard that I didn't even think about it.
Well, do you think the state government is accepting applications from parties or entities that don't exist? I'll tell you this. I'm not Mr. Freeman, and I think he's a very experienced lawyer, and I like him personally. If somebody pointed out to me that the Corcoran Company didn't spend $500 to incorporate Adams Court Property Owner LLC, and I heard that Monday morning, I would be at the Secretary of State's office Monday morning at 9:01 with a $500 check to make sure that the entity in my application does exist. All kinds of decisions and awards were made to this entity, which has no legal existence. I don't know what to say. I tried to explain it away in my decision here, and the only way I could do it is put nominal applicant.
Okay.
A named applicant that has no legal existence. And it's, I was shocked to read that from Mr. Galvin's submittal. I couldn't believe it until I checked it myself.
Okay.
Jeffrey, do you have any comment, or Nick, on the fact that this company doesn't exist and has been awarded these legal rights apparently by state officials?
It makes absolutely no sense to me how does an entity, we don't have an applicant if we don't have an entity. It's nonsensical to me as an attorney, but maybe it's customary, but it still doesn't make any sense to me.
Okay.
Jeffrey, what do you have to say?
Well, that makes sense to me. I think you dealt with it the best way you can. I am interested in custom and practice, but
Well, let me ask you this, Jeff. Does it make any sense to you, rather than creating the nominal moniker for this entity, to just take that out and put somewhere in the decision that the board has investigated and found that the applicant has no legal existence? How about that? That it's just a named entity, but it doesn't have an entity that exists by law, and not flag it as a nominal entity throughout the decision.
sure.
I mean, I don't care. It's maybe nominal entity makes it look silly, but the whole thing is silly if it doesn't exist. I don't know how you can apply for anything if it doesn't exist, but I think really the nominal applicant here, as I tried to put in my my draft here, is the Joseph J. Corcoran Company, LLC. Now, I suppose we could do that if you wanted to not to deal with nominal applicants and all of the concerns that arises. We could just say that that certainly the filings with us indicate that the Joseph J. Corcoran Company, LLC is the controlling member of the applicant. That's what they say. And the applicant is a joint venture between the Corcoran Company, LLC and the Falcone companies. So the other alternative is just walk away from the nominal applicant here and just say that the board finds and rules that the true applicant, or the real party in interest, if you want to get legalistic about it, is the Joseph J. Corcoran Company, LLC, and to let the decision run that way. What does anyone think?
What they say in their application is that it's a joint venture between Corcoran and Falcone. That's
Yes.
how they establish it.
That's right.
Yeah.
But so why don't we just walk away from Adams Court Property Owner, LLC, and just
Because the applicant entity is Adams Court Property Owner, LLC.
But there is no entity.
I think you're better off just staying with nominal.
You do.
All I was saying is that it's just non-standard, but if you're comfortable with it, I'd say let's just go with that and move on, because there's other things probably that are more important. I was just making a comment that it's non-standard. It's fine if you're comfortable with it.
Well, what concerns me, Judy, with all due respect, is that if based upon your experience, and I don't doubt it in the slightest, you tell us that it's customary, it's usual and customary for people to apply to the state agency for permitting under 40B.
They didn't. They didn't. I'm sorry, go ahead, John.
Yeah, I was saying using fictitious entities that have no existence at all. If that's what everyone's doing, I thought that's what you said.
They didn't apply to mass housing as Adams Court Property Owner, LLC.
Okay, then who
Corcoran.
applied?
Corcoran.
Okay,
Project eligibility letter.
okay, and that the project eligibility letter was authorized the Corcoran Company to be the entity that's pursuing this?
When they applied to mass housing, they indicated that it would be a joint venture between the two parties.
Okay,
And so the letter was simply back to Corcoran, that's all. But it acknowledges that it's a partnership between these two firms.
and that letter doesn't reference Adams Court Property Owner, LLC?
I'd have to go back and look, John. I don't know.
Well, to be frank, I don't, I've got so many papers on this that I don't have that immediately at hand, but
I mean, I can try to find it. I have the application.
in fact, I think I see it over the other side of the room. It's, if you have it handy there, let me know.
I'm trying to search for it right now.
Okay, I'm gonna step away from the screen for 10 seconds. Yeah.
So this is how it reads, or do you want me to wait till John comes back? I'm
So
sorry.
I'm back, I'm here, I have it here. Go ahead.
Right. So it's the 38th page of the application, and the project eligibility letter is in the application from Mass Housing dated August 30th, 2020 to Sean McReynolds at Corcoran. The second paragraph establishes Adam Court Property Owner LLC, the applicant, submitted an application to Mass Housing pursuant to Chapter 40B. The applicant proposes, et cetera. So the letter was directed back to Sean, but acknowledges that the applicant entity is this limited dividend organization that exists or shall exist in order to complete the project.
Well, at what time are they ever going to make it exist if
They have to do that in order to finish final approval with Mass Housing and apply for the building permit. The process that Charlie's going through right now with Mass Housing for Ice House is final approval.
Yep.
And all that documentation has to be in place in order to complete the final approval process.
John, what if we did both? What if we just called it the nominal applicant and we put a paragraph in here talking about the fact that we investigated and determined that it doesn't currently exist, but there is a condition in the permit that states that it needs to become a limited dividend corporation, and just put that on the record that way.
Well, I guess you could, but how do you weave in the Joseph J. Corcoran Company LLC, which does exist apparently?
Yeah, I don't think we want to give a permit to an entity that didn't apply.
Right.
You know? That's
Okay.
all. That's the issue I'd have with that. I think you're better off. I think you're on the right track there.
So the suggestion is to leave it as it is.
With another paragraph in here somewhere about a little bit of the background and why it's being called nominal. But I've got the document now, so I can do that. You know,
Well, on paragraph 22, at least this is my draft. We say that the applicant is a nominal entity which has not been formally registered.
oh, okay.
And as a limited liability company at the office of the Secretary of State.
Got it.
And then paragraph 23 says the Joseph Corcoran Company is the controlling member of the applicant. The applicant is a joint venture between the Joseph J. Corcoran Company and the Falcone Companies.
Yeah.
It says upon the issuance of a comprehensive permit, the applicant will be formally incorporated with the Secretary of the Commonwealth of Massachusetts and will be a limited liability company which has agreed to a limitation on its return on total investment in the project pursuant to the requirements of Chapter 40B and the related state regulations, and will satisfy all of the eligibility requirements to apply for a comprehensive permit as determined by the August 31, 2020 project eligibility order. So, I mean, it's all there. What's wrong with that?
No, nothing. What happened here, John, at least from my perspective, I thought we would get another draft. I'm not blaming anybody. I'm just saying that. I didn't study all the comments. I'm not ready to have this conversation. So I thought we were going to postpone it, and I didn't read it. So shame on me for doing that. But that's where I thought we were with this hearing. I'm working. I'm trying hard to catch up. But I don't remember all the comments. That's all. So.
Well, they're not, these are just suggestions to,
No, I know. But I didn't study everybody's comments because I was anticipating reading one decision, not three. That's all. So I haven't caught up to that, you know.
yeah, let me do this without, Judy, without putting you on the spot here. Can you tell us how far along we are in incorporating this stuff into a unified decision as opposed to, for example, if, you know,
Where I got stuck and I finally stopped because I knew that it was beyond what I could do, was the addition of the comments you had suggested, John, from the planning board and so forth. I just had, all that stuff had to be typed into the decision, and I just don't have that kind of time.
yeah,
I
well,
stopped there, but I believe everything else is in here, and I responded to some of the comments. I mean, I'm just as an example, it might have been Jeff, it could have been Nick, I don't remember who, but someone had said we should add in here that they have to come back to the board if they want to change the form of occupancy from rental to ownership.
Yep.
That doesn't need to be in the decision, it's in the state regs. So, you know, anything like that is already covered by some other jurisdiction just doesn't need to be in the decision.
What does the state reg say? The state
Pardon
reg
me?
say you have to come back to the Board of Appeals?
Yes, it does. So it's in the section on substantial changes, and for some reason, I can't find that comment right now because there's just too much here, but I did respond to that comment. It just doesn't need to be here. It's already in the state regs. Must be over in the conditions.
well,
Somewhere in
why isn't it so that,
This one,
why isn't it the responsibility here, not to drop all of these atom bombs on you, but why isn't the responsibility that of the town to get this typed up on an accelerated basis? For example, town council has, I think, Jeffrey, you'd know better than I, 40, 50 lawyers, 60 lawyers now.
John, I'm happy to do that. We're beyond that. We're beyond that. I'll type it. Just Judy, send me this document. We'll have
I
this.
will.
We'll
I
have
will.
this thing typed.
I
Okay,
will.
so that's not the issue. The issue is whether we're ready to have this conversation, and
Well, I think the answer is we're not. If that's
Yeah. That's right.
If you need more time to discuss this and to read it, and Nick, do you prefer to have more time to work off of a unified document, even if we end up giving it a haircut because some of these comments are too long or too not necessary, or as Judy says, if they're violative of some regulation or procedure. So if we put it in and then Judy says it's got to go, then we'll take it out.
Yeah.
But then we've got a document which will, once edited, is going to be pretty close to the final document.
So
Yeah.
some of the comments, are about things that just don't need to be here. And I think that's in the same vein what the building inspector was trying to say, that if it's stuff that's in the building code, it shouldn't be in the comprehensive permit decision because it doesn't need to
Well,
be.
that may be right, but we don't have the slightest idea what's in the building code. And that's the problem.
That's
We're
why
making-
he's gone through it. Right.
So,
understand.
to me, I think it would be a blessing for us to have this unified document and then go through it. And you could say, that's in the state building code, that doesn't need to be, out it goes.
Well, I think you've got that from the building inspector at this point. I think he's written that email.
Well,
Right, on a prior version.
if he's written it, he's commenting on a decision that's not even before the board anymore. We've substantially revised that decision.
I understand. I'm just saying that you have comments from the building inspector. That's all.
Well, I know that, but what good are they if they're on the wrong document? my intent would be to get this draft decision prepared, as Jeffrey suggests, and we'll send it to Mr. Prondak, and he can make all the comments he wants, as long as he does it in a timely manner. We're now going to be 25, 30 days into the decision-making process, and it is a little bit late in the game to be receiving these types of comments, but that's fine. If I appreciate it, I appreciate his effort in doing it, and regretfully, it's just on the wrong document.
John, unless the language that he commented upon just gets totally deleted, those comments are still operative. It's just a matter of where they fit into any kind of newly formatted.
Right.
I mean, when the section references will have to be, adjusted. We can keep track of that. The other thing that I would want to be cognizant of, with the building inspector's time, which he takes, this and all of his roles very seriously, is just, trying to keep this. And I think, to the effect of having a unified document that has everyone's comments in it, and we can track the changes, I'll want to be able to direct him to, here's what's consistent with what you've already looked at. Here's what's new from the board members or from other kind of conditions that have been added, so that he's not, effectively rereading another, 50-page document again, because.
Yeah, I appreciate that, Tim. I really do. But I have to tell you this. We've spent a tremendous amount of time and money on this particular project. And I feel badly that the building commissioner, Judy, has to look at things again. But I appreciate his comments, but to say this is already covered by the building code and the like, fine, but that doesn't mean anything to us, because we don't know what's in the state building code, and we need the guidance of the building commissioner to tell us. So I don't want to sound irritable or whatever, but.
Mr. Leonard, I'm willing to try to match up the building inspector's current set of comments with the revised document that Jeffrey and his firm are going to produce.
Yeah, I can do that. I'm doing that right now, Nick, actually.
Are you? Because I don't mind taking a crack at it. I could, with the various prior versions, I could probably do it.
It shouldn't be that much. It shouldn't be that.
It's just matching up the numbering.
Yeah.
Well, it's yes, it is, but it also is. It has to be reviewed and interpreted in light of any changes that we suggest, and changes that perhaps Judy or Tim suggests are not appropriate or need to be changed, or the language has to be modified. Those recommendations. We need to take those recommendations and make sure that Mr. Prondak's suggestions are appropriately considered with those changes in mind. Isn't that right? I mean, remove C3B, remove already governed by the building code. Well, that's great. But show me where in the building code is that already covered? Or we can say Mr. Prondak knows the building code and we don't, so take it out. So in other words, it's I don't know that they're covered by the building code. Joe's a bright guy, and if he says it is, that's fine. But there's no citation to it or whatever. So that's I just leave that to the bunch of us here. I don't think it, Nick, I appreciate your attempting to do this. If you can do it, take a run at it. But I don't feel comfortable that I could do it. But if you can, take a shot at it.
All right. Well.
So if that's the way we are, if today is Tuesday, today's Tuesday, are we going to be in a position to resume again on Thursday and have the opportunity to review and further revise this at that time, or is that too soon?
Yeah, it's going to be too soon, John. frankly. I mean,
How about Friday? How about Friday, the 8th?
Friday's better.
And by then, we should know whether the applicant is willing
Yeah.
to grant us what, a 10-day or a 14-day extension. To be frank, considering the length of time, Judy would remember when we first started the hearing process on this, but almost a year ago. I hope it may be
Well,
longer.
December 2020, it opened and then it was continued to May
Yeah.
to get the other cases moving forward.
Yeah, so it's a substantial amount of time we've spent on this application, and I would think that the applicant would want a decision that is worthy of what the board can produce with Tim and Judy's suggestions. And I can't imagine that going another 10 days or another 14 days would be detrimental to the applicant's interest. I would think that the applicant would be liberal in granting the board the time it needs to do this, knowing that the application is going, in all probability, in all likelihood, is going to be appealed. You would think that the applicant would be jumping for joy if we're going to spend another 10 days or 14 days on this matter. But I don't know. We'll certainly, if we go over to the 8th, we certainly will know from Mr. Freeman what his intention is. And if we get another 14-day extension, maybe we should meet on the 8th anyway and see what we can accomplish. But if not, if we have to go over into the next week and be better prepared to put this thing to rest, we could do that as well. Just depends.
What time on the 8th are you talking about? Because I actually have to be at a community meeting for a project up on the North Shore that night.
Yeah, Fridays, can we meet any earlier on Friday, if that's the case?
I got a job. I mean, it's tax
understand.
season. I got work coming out of my ears. It's really hard to meet during the
This
work.
is a really bad time of year for everybody.
Yeah, it's
I'm
like
telling you.
I got 3 estates to settle, and
Yeah.
I'm just there's people keep dying.
Yeah.
Well, you may have more estates coming up in the future. Wait,
It's recession proof, right? Yeah.
it is recession proof.
So
You're
my
just-
only,
you're just
my
due
only,
diligence. Go ahead, Judy.
my only constraint is I am committed to being at a community meeting for a planning project up in Amesbury that night. And right now, I wouldn't know who could cover for me on that.
Okay, so that doesn't work. I don't want to have a meeting discussing the decision without your personal expertise available to us.
Do you folks ever meet on Saturdays? Some of my boards do. I just thought you'd be thrilled at that idea.
No, actually.
Would Monday work, or is that calling it too close?
Well, the decision, unless Attorney Freeman agrees to grant an extension, the decision has to be filed the next day.
By Tuesday?
Yeah. Oops. I'm gonna take this down.
And I am not available Tuesday the 12th, for that matter, in the
Are
evening.
are you available on Saturday the 9th?
I am. Look at those eager faces.
I mean, if it's necessary, yeah. I mean,
Well, maybe, Nick.
I'm not going anywhere, so
I will tell you this, based upon my training background, experience, and wisdom, I will do 100 push-ups if Mr. Freeman doesn't give us an additional 10 to 14 days, period. So I tend to think what I'd like to do is this. Jeffrey, could you give us an hour or two on the 9th if we really had to have it? But I think it's not going to be necessary.
I just, okay.
I mean, what are we going to say?
No, that's fine.
If he says no, we've got to be prepared to do what we don't want to do. So my suggestion is we go over here to the 9th at, let's say, 10 o'clock or something like that, with the proviso that if I keep saying Mr. Freeman and I shouldn't, if the applicant or the Corcoran company gives us another 14 days on this, then the hearing on the 9th will automatically be continued to some date that's agreeable during the week of the 11th. And we can pick that date now if we want to do that. Does that make any sense? I'm picking a date that if we are jammed, we're going to need it, but I don't think we're going to be jammed, and I don't think we're going to need it. But it's precautionary. I guess that's what I'm trying to do here. So in other words, we plan a meeting for the 9th, but it's our hope that it can go over to some date, not the 11th, but some date later in the week of the 11th for further discussion. And at that point in time, we should have a draft decision. We should have an opportunity to review it. Judy can review it. She can redline it, cut it to pieces, whatever she wants. So Tim can strike it. Jeffrey, no. Nick can take and try to incorporate Joe Prondak's suggestions into the new decision, and we may be in a position that we can put this to rest, or at least do the final editing that or excision of particular paragraphs or phrases or clauses or that would make us in a position well before the end of the deadline to get this darn thing filed and to move on. I think it's bad judgment to go over to the 11th in the event that we guess wrong and Mr. Freeman is instructed by his clients not to grant any extensions.
Yep.
We are then up.
Let's schedule it for the 9th. I'd support that.
What time did you say? 10 o'clock?
Nick, are you able to do that? I hate to do it.
I mean, the following week is Holy Week, so I'm committed on Thursday night and Friday night for choral services at All Saints. So next week is the end of the week is going to be tough. So
the following week is already booked too, just to let you know, for other 40B cases, Tuesday, Wednesday, Thursday.
Awesome.
How lucky.
So Saturdays, yes, I can meet on Saturday.
Crystal, are you able to do that? And let me ask you this: I don't have the slightest idea. Is Milton Television able to do something on?
I honestly have no idea. I can talk to Shane tomorrow and see what he says. I don't know.
Where it's not a public hearing.
I can always just record it, and
Right.
I can upload it and just put it on the town website. It doesn't
That's
have
right.
to be live.
That's
Okay,
right.
you mean a tape recording of it as opposed to?
Yeah, so I can just hit the record button when we're ready to start. We don't need Shane to do the countdown. And I can just upload it to the town website, just so it's documented.
Okay, that makes sense.
Well, if it's just a
Yeah.
regular meeting, that's fine.
Right.
Do you guys
So,
want to do this remotely, or do you want to meet in person?
No, it's going to be.
Just asking. Just asking.
Crystal, are you able to be in attendance on your day off Saturday at 10 o'clock for all of this stuff?
Yeah, that's fine. Are we doing it via Zoom, or are we? Yeah. Okay. Okay.
Okay, so then correct me if I'm wrong. The procedure is that we're going over to Saturday, the 9th at 10 o'clock. In the event that the time for filing the decision is not extended. If it is extended, then I will, let's say for 20 days, either let's call it 14 days after the 12th, which is a magic date now, then what I will do is I will continue this hearing on the 10th to tell me when the next hearing date's going to be, what is convenient for everybody.
You mean if we don't meet this Saturday, is that what you're
Yeah,
saying?
if we don't meet the Saturday because the applicant gives us an extension of 14 days from the 12th, that would be, I think, to the 24th of April, then I will continue this hearing on the 9th at 10 o'clock to what next date for review of the draft decision.
So it would have to be the 18th, a holiday, it would have to be the 19th.
Yeah. I'm supposed to be out of state, but okay.
Okay, or the 21st.
I don't know what nights I'm available because every night of every week I have Board of Appeal hearings on my calendar, but I don't know which hearings those are.
Yeah,
They don't have the name, so I don't really know.
yeah.
So if there's no hearing that night, I mean, I'm going to be at the board. So if this is the board hearing, then I will come. So that would be good. If there's no other hearing on the 19th, that works for me.
So far, there's nothing on the 19th or 21st. And I know Canton Ave cannot meet that week at all. So the
Right.
only hearing so far is on the 20th, that Wednesday.
Yeah, I have that. Okay.
So
Why don't we look at the 19th?
What'd you say, Judy? I'm sorry.
I'm sorry, why don't we look at the 19th then?
19th, okay.
Nick, does that work for you?
I'll be driving home from New Jersey. If it's possible, I can be back by the evening.
So
Should
would
be.
you prefer to go to the 21st?
No, I
then?
mean, I should be back unless there's traffic. I have a car break.
Come on, no.
I mean,
We're not
or I
going
could
to
be on 95 and just go in with a phone.
Yeah,
Because that'll work real well.
That's not, no. Jeffrey, are you available on the 21st date?
If there's not a Board of Appeal hearing that night, I am.
There's nothing right now. So
Okay.
those dates that you're seeing, the Tuesdays and Thursdays that look like they're kind of just they're just keeping the spot for an open hearing until I send the invite.
The
And
place.
you have to accept the invite on your calendar. Yeah, they're just placeholders.
Okay.
Yeah.
Yeah.
Judy, how about the 21st?
I'm putting it in my calendar right now.
Okay.
As far as I know, that is available.
Let me, bear with me. I need about 10 seconds to run and get my iPhone because if I go to my calendar on my computer here, I'm going to leave this meeting and we'll never be found again. But just bear with me. Done deal, 21st. 21st at 7 PM.
Okay.
Okay.
All right. Anything further, Jeffrey, that you want to add? Or
Not tonight. Thank you, John.
okay, Mr. Gray,
No, nothing. Thank you.
Miss Judy?
No, John.
Judy, can you send me that document?
Yes, sir.
Thank you.
Thanks, Judy.
Okay, so we're going to adjourn this particular hearing until
Thank you.
Saturday, the 9th at 10 a.m. And if we get an extension from the applicant, then I will continue that hearing formally with Crystal being on board. At the 10:05 Saturday until April 21st at 7 p.m. And if we do not get the extension, then we'll go forward with our further deliberations on Saturday, the 9th.
Crystal, would you mind sending an invitation for the Saturday?
Yeah, of course.
Thank you.
Okay, if there's nothing further before us, then we'll be adjourned until Saturday, the 9th at 10 a.m. And hopefully we'll not have to convene, but for the purpose of continuance. And I'll handle that myself. We don't need any other person present except myself and Crystal, and that'll be for 90 seconds. Okay,
Okay.
All right.
great.
Thank you.
Okay, thanks, folks.
Thank you.
Thank you.
All right.
Have a
Thank you
good
very
night.
much.
Be safe. Bye-bye.